Hello, students. I want to go through the constitutional amendments with you so you understand not only the shortcuts that we call them at Shanley High School, but also um, the the meaning and the kind of description of each of the amendments. First of all, realize that the Constitution is made up of 7 articles, and these are the changes or the amendments that have been done to the Constitution. The first 3 articles set up our 3 branches of government, and then Articles 4, 5, 6, and 7 deal with a few different things, the ratification, the amendment process, and so on. So do realize that the amendments are just the additions and changes that happened after the Constitution was originally ratified. And speaking of that, the first 10 amendments are known as the Bill of Rights. This is what it took to get the Constitution passed. There was a lot of disagreement between the federal power and the state power, and as we find out, the federal government needed to have a stronger central government, but the states oftentimes were opposed to that. So in order to get the Constitution passed, we had to add the first 10 amendments, which become known as the Bill of Rights. So what I want you to know are the what we call the shortcuts. This is a long history in Shanley High School, going way back to Mr. Randall Rusted, a very legendary social studies teacher at Shanley High School. He was known to do orals kind of whenever it worked for students, and he was bound and determined that every student would know the amendments to the United States Constitution. So starting with number 1, freedoms, remember it as RAPS, religion, assembly, press, petition, press, speech. One thing that I'd like you to make sure you understand, religion is not only the freedom to choose your own religion, it's the freedom to not be religious as well. Our country was based on religious freedom, but that didn't mean that you had to be part of a faith or part of a certain religion. So it was the right to worship or to not worship. In this First Amendment, things like press and speech, these all have long standing roots in the deliberation and the fight between the powers of Great Britain and the newly up and coming states. Before the colonies and the colonists were very unhappy with the way the government was working in Great Britain. And so you can especially see in the first 10 amendments, primarily in the first one, that this has a lot of roots tracing back to Great Britain. Number 2 is guns. It's the right to bear arms with limits. The Constitution talks about a well-regulated militia. That you have the right to carry a weapon and have a well-regulated militia. Number 3 is troops. You don't have to quarter or house troops. This goes back to the Quartering Act of 1765, when the Great Britain required colonists to house British troops in America, before it was called America at that time. Warrants, you can have no illegal search or seizure. Many times this especially had to do with customs officials. They would look through goods that were being sent out through the ports, especially looking for smugglers, which did happen quite a bit. But you need probable cause, and oftentimes they were just searching through goods and trade goods for no reason. Number 5 is silence. The first understanding of this is that you don't have to self-incriminate. We will talk about the Miranda versus Arizona, the Miranda rights. But within silence itself, there are a few different kind of sub-points, if you will. Grand jury determines basically if there's enough evidence to even go to a trial. We don't want to waste taxpayers and people's time, so we need to make sure that there is enough evidence to have a trial. Eminent domain says that the government can take your property, but it must be with just compensation for the good of the people, for the common good. Due process. Now we're going to see another one in the 14th Amendment, but due process under the 5th Amendment is that there's a series of steps that protect the rights of the accused and how the law will proceed in a court of law. There's a certain series of steps that you must abide by. And then the last D in GED is double jeopardy, which means you cannot be charged with the same crime twice. Moving on to Amendment 6, this is attorney. You have the right to an attorney. If you cannot afford one, one will be provided. Again, this goes back to in colonial times, you were sent to Great Britain for your offenses. And so oftentimes it was not for instance, in front of a jury of your peers. It was not an impartial jury, nor speedy for that matter, if you had to go by boat to sail back over to Great Britain to be sent for trial. I like to think of this as Spiff J instead of the word spiffy, SPIFJ. So I think of speedy trial, public trial, impartial jury, face your accuser, and then jury of your peers. It's just a way for me to remember the word spiffy, but instead of the Y, it's a J. You need to have an impartial jury, for instance. It cannot be biased. When we talk about a speedy trial, do understand that even yet today, trials can take months and sometimes even years. You can, what we consider speedy might not be the justice system's idea of speedy. The point of a public trial is that the public should be kept informed. It should be in the area, at least, where the crime was committed. And if you cannot have a impartial jury and a non-biased jury, then it might be moved. But it really should be at least in relatively the same area where the crime was committed, simply because there are cultural, maybe even geographic, ecological factors that might be true in one area but not true in another area. So it's important to have the public trial. $20, we call it $20. Mr. Rusted said $20. This was in civil cases. It's not really used today that juries could decide. You had the right to a jury trial, and juries would decide the trial in cases involving more than $20. Today, $20 is really not an issue, but it has never been changed. So criminal or civil trials now, really, this is very little abiding by the 7th Amendment. Punishment. The 8th Amendment says that you can have no cruel or unusual punishment, especially while you are imprisoned waiting for trial. Some states will say that the death penalty is considered cruel and unusual punishment as a result of finding the defendant guilty. Other states allow the death penalty. Number 9 and 10 oftentimes kind of go together. They're called, number 9 is unenumerated rights. What the Constitution says for number 9 is that there are more rights that the states have than what are listed. Unless they are explicitly listed, the power belongs to the state. The state has more power than the federal government, and those unenumerated rights, there's so many of them that they can't all be listed. That power then goes to the states. And so the same is basically true with state powers. Anything that basically is not granted to the federal government is reserved for state power. So for instance, education, licensing division, speed limits, things like that all go to state powers, and states have authority. So for instance, in the state of North Dakota, our driving age or our speed limit might be something different than, say, in the state of Minnesota. So those first 10 amendments: freedoms, guns, troops, warrants, silence, attorney, $20 punishment, unenumerated rights, state powers, are what we call the Bill of Rights. Now moving on to the next amendment, state lawsuits. This came shortly after the ratification of the Constitution, 1793, I want to say, that basically said the federal government must stay out of state lawsuits. It happened after, I want to say, South Carolina sued, some men in South Carolina sued the state of Georgia. And they said that that could not happen that way. That states could not be sued by other states. Number 12. Number 12 is a very important amendment. It came after the election of 1800. We call the election of 1800 the Revolution of 1800. And this was the election between Thomas Jefferson and Aaron Burr. It ended in a tie. Jefferson and Burr were the running mates. And what we saw is that one would have been the president and one would have been the vice president. They were elected to the same ticket. And so it made a very, very sticky, complicated process. So now we have the amendment that says the president and the vice president cannot be from the same state, and you must, the winner will have their own vice president on their ticket, and the runner-up will be the loser. They will not become the vice president. Number 13, 14, and 15. This is what we refer to as the Civil War amendments. 13 is slaves. It abolished slavery. This is 1865. It superseded Article 4. Article 4 was the relationship between the states, which basically talked about the Fugitive Slave Act. And it said that slavery was no longer allowed in the United States. It would have done away with the 3/5 compromise. Well, we will see that for sure in the 14th Amendment. But you could no longer, and there is one small loophole, if you will. You cannot enslave people or use them for human labor unless it's a condition of imprisonment, which is one of the reasons why prison population soared after the Civil War, because you could go to jail for even the smallest of violations, petty crimes. So it was a way to get around sometimes these new amendments to the Constitution. Number 14 is civil rights. I would like you to remember Cade. These were civil rights basically granted to former slaves. By the way, number 14, the 14th Amendment, is really the one that is used most often in court cases today. You see, again, due process, the way it is in the 5th, we see due process now at the state level. Let's start with citizenship, though. This gave citizenship rights to all Americans, except, I should say, they were subject to U.S. jurisdiction, which means that Native Americans still did not gain citizenship rights, even with the 14th Amendment. Apportionment, this is where the 3/5 compromise is abolished and people are counted as a full person. Again, Native Americans were not included in the apportionment of the Civil Rights Amendment. Due process at the state level, this is where we see a lot of court cases and laws pertaining to, for instance, abortion, marriage. Different states can have different rules of due process and the series of steps to protect people and to give people their rights. And the E in civil rights is equal protection under the law. Before the 14th Amendment, especially Black Americans, but there are people who did not receive equal treatment and equal protection under the law. Some of the most egregious examples may have been with fire protection or police protection. If your house is on fire, you lived in a predominantly Black neighborhood, they could deny coming to put your house out, the fire department, after the 14th Amendment that said you deserve to have equal protection. The 15th Amendment, this is men, that said that race could not be used as a criteria for voting and all men could vote. Now, for instance, the 15th Amendment wasn't passed until 1870, which is 5 years after the end of the Civil War. But again, we call the 13th, 14th, and 15th Amendments the Civil War Amendments because it was really the Civil War that was fought to grant these very necessary amendments. Number 16. This is an interesting one that we just do a shortcut called tax, but you should understand that this came out of the Progressive era, the rise of the People's Party or the Progressive Party around 1912. They wanted to have a graduated federal income tax. Before, income tax had almost been impossible to collect. And this changed it to have a graduated income tax. And so now income tax is basically based on what's called your tax bracket and a certain percentage of how much you make depending on where you fall in the tax bracket then goes to the federal government. Number 17 is Senate. There would be a popular election of senators. Before, senators were elected by state legislatures. State legislators, it had been building, but especially by the time we get to this time, in the late 1800s, early 1900s, state legislators had become very corrupt. And basically you could buy your way into the Senate, which was called the Millionaires Club sometimes. And so now they had to actually change the Article 1 of the legislative, that set up the legislative branch, how senators were elected. And now it would come by popular election by the people of the state, not by the elected state legislators. Number 18 is booze. This was during the time of Prohibition. It outlawed the manufacture, sale, and transport of alcoholic beverages. What it didn't outlaw was the consumption. This is where we see bootleggers coming into effect. We see speakeasies happening to try to get around the amendment of outlawing alcohol in the United States. It passed in 1917. It was ratified not until 1919. Eventually, we'll see this is the only amendment that is actually repealed. So, as Mr. Rusted would like to say, 18 is booze, 19 is women, because booze came before women. This is in 1920, shortly after the ratification of the 18th. It now said that gender could not be used as a criteria for voting. The women's movement, as well as the temperance movement, I should add, people like Susan B. Anthony fought very hard for women to have the same rights as men, especially after the 14th Amendment. Many women in the suffrage movement suffragettes felt like there was no reason that they needed to have a 14th Amendment simply because a 15th Amendment as well as a 14th, but a 15th Amendment because it basically was still continuing to exclude women. But as it was, the 19th Amendment got passed, and Wyoming actually was the first state to pass an amendment saying that women can vote. That was way back in 1890. But other states didn't allow it. Many southern states didn't allow it until it became a federal mandatory law in 1920. Then we go on to number 20, January 20th, January 3rd. We just say Jan 20/3. This was the January 20th is the start date for the president and for Congress. So the president is January 20th. Congress is January 3rd, because the travel time in 1930 was a lot longer. This is the year it was passed, was a lot longer. So after the November elections, they needed time to literally get to Washington, D.C. This was a this is also going to be altered actually by the 25th Amendment coming up here in a little bit, but it put an end to what we call the lame duck session. The lame duck is basically November through January, where like nothing really happens. I'd like to say it put an end to it, but there's still sometimes there's a flurry of legislation that can happen in that time between November and January, and sometimes very little happens. Number 21 is an X. We just put X because it repealed the 18th Amendment. This is in 1933. So when the amendment on alcohol was passed, the 21st Amendment repealed it, but it did set the drinking age to 21. Federal funds are provided to states who set their age at 21. So if states get money from the federal government if they have a legal drinking age of 21, if they would have it less than that, they would not get federal funding. So all states at this point have at age 21. Number 22, that one's an easy 2 by 2. 22 is 2 by 2. This set the term limits for presidents. They were limited to 2 terms of 4 years. So 2 times 2 is 4. This came after, in 1947, after President FDR, Franklin Delano Roosevelt. He actually was elected 4 times. He didn't quite serve 4 terms, but he was elected 4 times. There had never been an amendment that said a president couldn't do that, and so they needed to change it because they realized having a president in the executive office for 16 years was really it was too much, and so they made the amendment after FDR had died. Number 23 is DC. This basically made DC have 3 electoral votes, or as many as the least populated state. They recognized Washington, D.C.'s citizens as federal citizens, so they're not state citizens, but they're federal citizens, and D.C. was treated as a state in the electoral process. So Washington, D.C. gets 3 votes in the electoral process, and that's how people in Washington, D.C. can also vote. Number 24 is the poll tax. This eliminated the tax to vote. What's really kind of unfortunate is this didn't come until 1962, which means that the Jim Crow laws that were set up in, the Civil War amendments to get around things like equal protection under the law, and things like a literacy test and issues like that, it finally put an end to some of those laws. So they said that you could no longer pay to vote, and it eliminated that tax to vote. But that's not until 1962. If we think about when the Civil War ended, was in 1865, almost 100 years earlier. There was a very long time of deeply segregated, deeply racial ideology that was happening in many states in the United States. Number 25 is what we call secession, or TV, transfer of power, and VP, vacancy. Those are the 2 subpoints. The secession is related to the order of presidential succession. Now, this was passed after JFK's assassination. It goes from the president to the vice president, then to the Speaker of the House, to the President pro tempore of the Senate, and it goes on so forth after, on and on, kind of in the cabinet positions in the order they are created. And so if for some reason the president cannot be the president, then they can pass on the power to the vice president, or is given to the vice president. If the vice president could not, then it would go on to the Speaker of the House, so on and so forth. So let's talk about that transfer of power. The president can temporarily transfer power to their VP, or the vice president or a majority of the cabinet can request that Congress transfer power to the vice president. So, for instance, it's happened a couple of times in recent history. But for instance, if a president might be going in for an elective surgery, say, and they will be under anesthesia and they cannot carry out their duties as president, they can, for a period of time, give their power to the vice president to make the necessary adjustments, or be the president in those times, for instance. VP vacancy says that the president must nominate a replacement. So if there's a vacancy in the vice presidency, the president must have a vice president at all times. This again happened in Nixon's term after JFK's assassination, which you will find out about, I'm sure, in government class. Number 26, is 18. This lowered the voting age from 21 to 18. It happens not coincidentally, I will say, in 1971, in the Vietnam era. Many young men who were going to Vietnam to fight could not even vote, in order to say whether or not they wanted to have people in power who were making those decisions about entering a war such as Vietnam. And so it modified actually the 14th Amendment, and it lowered the voting age from 21 to 18. And finally, 27 is a very unique amendment. It's pay raise, and it said that Congress sets its own pay. So Congress gets to decide how much they make, but any changes, whether it's an increase or a decrease, does not take effect until the next term begins. So for senators, that's 6 years. For the House of Representatives, that's 2 years. What's very interesting about this one is it originally was proposed by James Madison way back at the very beginning of setting up the Constitution. Sometimes James Madison is known as the father of the Constitution. It wasn't ratified until 1992. So for a very long time, this was one that had actually been passed and never ratified. It was never made into a constitutional amendment. So those are what we call the shortcuts. Learn to love them, because they are what makes Shanley Social Studies Department known for being so well versed in our American Constitution. All right, talk to you later. Goodbye.